Hello and welcome to today's web seminar, How to Effectively Contract for Excess Capacity and Reduce Risk. Today's web seminar is brought to you by the transportation insurance experts at Cline and Cline University with special guest speaker Henry E. Seaton, Esquire. Before we begin, a little bit about the technology we'll be using today. If you could advance to the next slide, Mr. Speaker. All of your lines have been muted for the duration of the web seminar. However, you can enter any inquiries that you have at any time. We'll queue them up for a question and answer period at the end of the web seminar. You can also slide this GoToWebinar box closed by clicking the orange arrow or double arrow, but do not click the black X or you will exit the web seminar. Now to introduce our speaker. Mr. Seaton is a 40-year veteran of the transportation litigation industry, a graduate of Duke University and Vanderbilt Law School. He serves on the editorial board of Overdrive Magazine and Air Forwarders Association Quarterly Magazine and is a contributing columnist for Internet Truckstop Magazine. He's on numerous boards and associations. He was also recently awarded a Lifetime Achievement Award from the Transportation Lawyers Association, making him a true subject matter expert for what we'll be discussing today. With that, please welcome Mr. Seaton.
Good afternoon, everybody. We're going to talk about, I think, a very important topic today. There are three convergent changes of wind going on in the trucking industry, and I think we're all very aware of the fact that for the first time in years, there is far more demand for capacity than there are trucks. There's a driver shortage, which is being exacerbated by hours of service productivity problems. The cost of new equipment is limiting capacity and driving up cost. There is an additional demand for equipment, and shippers are increasingly expecting carriers to meet fluctuating seasonal demands, particularly in the truckload market. One of the major obstacles to expanding fleet capacity are legal and regulatory impositions by the FMCSA and at various state and federal levels. I think particularly in the truckload market, which we'll concentrate on today, the owner-operator model may well have far in excess of 50% of the capacity model. The independent contractor model, as we all know, has been under attack for the past 10 years. Independent contractors offer a need of flexibility to asset-based carriers. They make good use of older equipment. They provide us with motivated manpower who can manage their own assets. And the survival of the independent contractor model is certainly something that we would like to encourage. But at the same time, we have to recognize that it's largely dependent upon federal and state tax treatment that treats the independent contractor as his own employee who is treated with on a 1099 status. Increasingly, we're finding that one size does not fit all. We have 50 states. We have different attitudes towards the treatment of the independent contractor. We have pro-labor legislation in over 24 states that's trying to change the state law with respect to workman's comp. And they're really basically modifications of two separate kinds of tests to determine independent contractor status. At the federal level, in many states, we have what's called a 20-part control test. And actually, it's difficult to have an independent contractor meet the 20-part control test because he's in the same trade or business that the motor carrier is. And but for a safe harbor provision in the federal regulations, we would have a real difficulty meeting it on an IRS level. There's also what's called the ABC test that's employed by certain states, and depending upon who looks at this test and how they apply, it's getting increasingly easy for pro-labor forces to classify independent contractors as employees, and the misclassification issue is becoming a serious problem. I think most people are aware that there are recently 3 bad decisions in California New York, for example, is a difficult state to beat the independent contractor status, as is a number of other states. So as a result, many asset-based carriers are looking for an alternative hedge to increased use of independent contractors. How do we manage to procure 10 to 15% additional capacity at any given point in order to meet the fluctuating demands of customers? When we look at that issue, we find that we immediately run into what's called MAP 21. I think everyone knows that that was a huge act passed by Congress 2 years ago. In among its 500 pages was a provision intended to deal with the double brokerage issue and intended to increase the amount of the broker's bond so that carriers who transported shipments would get paid. But actually we found that no good deed goes unpunished, and that in the course of passing that legislation, Congress eliminated what we call convenience interlining. Convenience interlining is the old concept that a motor carrier like a freight forwarder could accept responsibility for a shipment from origin to destination and subcontract that shipment to another carrier who was licensed, authorized, and insured. As a result of MAP 21, the ability to interline is now limited to those situations in which the origin carrier either picks up or delivers the shipment and handles the shipment a portion of the way. So technically it's impossible now for us to merely subcontract by retaining a backhaul carrier unless we comply with MAP 21. I'll talk about how to comply with MAP 21 in a moment, but other contractual impediments to outsourcing include SMS methodology. Increasingly, we are seeing shippers who are frightened by the FMCSA's efforts to raise the safety bar into believing that they must second-guess the agency's decision with respect to hiring subcontracted motor carriers. As a result of this, we're seeing in contract provisions that say that the carrier must provide service on equipment that it owns or operates. There's a nervous response on the part of the shipping public to brokered freight, and there is this increasing tendency on the part of shippers to hand a would-be broker a carrier contract in which the broker is named as a transportation service provider, one who is accepting responsibility for cargo loss or damage. In addition to the vicarious liability issues that are threatening us, there is the situation in some states where if a broker accepts too much control over the motor carrier that it hires, the court will presume that broker to be a de facto carrier and hence liable for the negligent acts or omissions of the subcontracted carrier. There are, in fact, and I think we all know, plaintiffs' bars that are specializing in broker busting, which is to go up the supply chain to the one who hires the small carrier to get larger verdicts. So swirling in this stew of limited capacity is the additional implications of outsourcing and vicarious liability. So clearly carriers need to outsource to get additional equipment to meet the changing demands of shippers. They need to meet the shipper contract requirements. They need to be able to limit their exposure for vicarious liability. How do we do that? Well, under MAP 21, there are two ways in which an asset-based motor carrier can outsource or obtain additional capacity other than the use of independent contractors. And those two types of intermediaries are property brokers and freight forwarders. On this slide, I've set up a little bit of the distinctions between property brokers and freight forwarders. let's go through this, and I think you can quickly see where we're going in terms of how to limit risk and obtain additional capacity. A property broker is a mere arranger of transportation. They do not issue bills of lading, while by contract they could accept cargo liability as an instrumentality of transportation. They do not. They have a constructive trust obligation to receive freight charges in trust and to pay the motor carrier upon receipt. Most frequently by contract they accept that obligation by guaranteeing the payment. The freight forwarder, on the other hand, acts in a dual capacity. With respect to its customer, it acts as a carrier in the sense that it issues the bill of lading, so it is able to control the contract of carriage. It accepts cargo liability, but it can limit that liability, as can a motor carrier. So while it might have Carmack liability for cargo loss or damage, it can control the amount of the liability. Both the property broker and the freight forwarder satisfy the MAP 21 compliance requirements because they have a $75,000 bond. When we get to the insurance issue, you'll find that property brokers by necessity virtually are required to purchase contingent cargo insurance or some way to limit their risk when the small carrier they hire is unable or unwilling to fulfill its cargo duties. And a lot of those problems arise out of the fact that it's difficult for the intermediary to determine whether or not the contracted motor carrier's insurance covers all risk of loss or damage. Many small carriers obtain insurance, even in the cargo arena, that's limited to specified vehicles. Oftentimes their insurance doesn't have cover refrigerated problems, wetness, dampness, or moisture, or theft. And if you're acting as a mere arranger, your shipper is by and large going to expect you to ultimately keep your hands on the cargo loss or damage and adjust the damage if the small carrier can't pay it. One of the frequent problems we incur with contingent cargo insurance is it doesn't really offer $1 coverage. It follows the form of the underlying carrier. So if he didn't have insurance, you acting as a property broker don't have insurance. On the other hand, when one acts as a freight forwarder, one accepts liability for cargo loss, satisfies its shipper's demands that the cargo claims be adjusted, and upon adjusting those cargo claims has a statutory right of indemnity to be recompensed by the carrier it hires. That's because the so-called cargo liability regime of the Carmack Amendment says that a freight forwarder, like a motor carrier who interlines, has the right of indemnity from the carrier in whose possession the loss or damage occurred. So both a property broker and a freight forwarder are required to retain licensed, authorized, and insured motor carriers, and can do that by contract. In the case of a freight forwarder, that's called typically a concurrence, but looks very similar in terms of its content. Let's look now at what I would call a comparative analysis of obtaining excess capacity through a freight forwarder affiliate versus a property broker affiliate. Under MAP 21, there's much confusion over whether or not a carrier can merely obtain a broker's license or a freight forwarder permit in its own name and have this somewhat awkward position of wearing two hats. And the statute actually has been interpreted by the FMCSA to simply require that there be a separate license. But best practices would suggest that whether you set up a property broker authority or a freight forwarder authority, it should be in a brother-sister corporation so that there will be no mistaking on the part of the shipper or the contracting carrier or on the part of plaintiff's bar that you were acting as the role of an intermediary rather than as one primary liable for both the cargo loss or accident liability. So if we decide that the best way to comply with MAP 21 is through an affiliated company, the question becomes, should it be a property broker or a freight forwarder? It's my belief, based upon a good bit of experience, that using a freight forwarder affiliate is a whole lot easier sell to a major shipper than is a property broker affiliate. The reason for that is most of the major contracts I see by shippers want their contracting party to be a, quote, transportation service provider and not a mere arranger. They want the contracting party to accept and adjust cargo claims. They want the contracting party to not have the patina of being their agent with respect to payment of charges. So when it comes to going to a major customer and saying, listen, in order to comply with MAP 21, I need to outsource some of your freight, it seems to be a whole lot easier to say I have got a forwarder affiliate who will accept liability than it is to convince them that you will handle the cargo claims if it's on your truck, but you won't if you need to facilitate outside capacity. The advantages of the alternative forwarder model are that you can obtain or work with small carriers on a load-by-load basis without assuming safety compliance responsibility, which accompanies the owner-operator model. I think, as we all know, everyone is particularly concerned about their own SMS scores, about the fact that one owner-operator or one last hired can very well get you in safety jail. And when you use a freight forwarder affiliate as a non-asset-based motor carrier or a non-asset-based service provider hiring independent contractors, you're not responsible for the safe operation of those commercial motor vehicles. They don't hit your safety score, so that is certainly a benefit. All of the problems of misclassification, all of the problems of being responsible for workman's comp, slip and fall on the part of the driver, or the if he's your independent contractor, all of those issues largely go away when using the alternative model. Also, by using the alternative model and putting a good non-back solicitation provision in your forwarder carrier contract, you can eliminate poaching. At the same time, you can control the issuance of the bill of lading. And by controlling the issuance of the bill of lading, you can reduce the possibility of theft by making clear who the pickup carrier is going to be, yet controlling through your service terms and conditions as a freight forwarder how claims are going to be handled, what service is going to be rendered, what payment terms are. It's all too frequently do I see cargo claims run awry because carriers or brokers have not properly limited the liability for cargo loss or damage, and all of a sudden they find they have got a shipment that's worth far more than their insurance. When you control the issuance of your own bill of lading, you're able to ensure that the carrier is given the shipper is given an opportunity to declare a higher rate, and your ability to fend off some of these major judgments. I'm sure there are people on this call that are aware there's been a recent $6 million judgment against a carrier because the contracts were not in order and the limit of liability was not perfected. So a freight forwarder model and the ability to issue a bill of lading is an important advantage. As mentioned in my bio, I do some work in the air forwarder industry, and I have seen how acting as a forwarder you can control your service terms and conditions in your issuance of the freight documents, which I believe is a real plus. In addition, using the forwarder carrier agreement, you can contemplate the use of power-only and semi-dedicated moves. I have seen power-only be used effectively in the intermodal industry, where we have chassis and containers that are not carrier-owned, and also on drop and pick shipments where small carriers are used intermittently to serve major shippers with shipper load and count movements. In addition, there is a certain contracting simplicity and less wordsmithing that is necessary when you use a forwarder to carrier agreement rather than the rather obnoxious, the typical 15 to 20 page broker carrier agreements that we see. Let's talk for a moment about how to implement the freight forwarder strategy and outsourcing freight. Well, if you see the need to obtain additional capacity, first thing would be to obtain a freight forwarder authority in an affiliate's name and post a bond. If the agency ever gets around to changing its procedures, that's ultimately going to become a fairly complicated process. Currently, it takes about a month to get the authority and maybe $1,000 worth of expense, and the bond should cost you something less than $2,000 other than the setup costs for the forwarder. You establish a freight forwarder affiliate, and I would recommend that you do the website work necessarily to establish it as an instrumentality of transportation and put its service terms and conditions on your website to apply by default if there's not the necessity of a written bilateral contract with your shipper. You provide inclusion for the freight forwarder by reference on your bill of lading, so that if you're ordinarily acting as a carrier vis-a-vis your shipper, but there is a load that needs to be outsourced on the load confirmation sheet, you would say service provided by Seton FF, and you would be able to meet the requirements of MAP 21 to show that the shipment was not being handled as an asset-based provider. Finally, on this slide, I have given you some of the language that a number of my clients have used to modify their existing shipper carrier contracts in light of MAP 21 to introduce the freight forwarder affiliate. Now, this is not to say that this language is that simplistic. You've got to look at the contracts you otherwise sign to be sure that this is a perfect fit, but you can see the simplicity involved. For operating convenience and to fill the shipper's transportation notice or needs with notice at time of booking, services may be provided by whatever the name of your freight forwarder is, carrier's affiliate. Freight forwarder warrants it'll be solely responsible for retaining and paying independent motor carriers which are properly licensed, authorized, and insured to provide service. That language satisfies the shipper's angst that somehow he would be liable for the acts or omissions of the carrier you select. Then the language would say freight forwarder will issue its bill of lading identifying the origin carrier, that's the guy you hire, and shall be responsible for handling and payment of all cargo claims in accordance with the contract terms set forth herein. So you're saying, look, I'm going to bill you. I'm going to bill you the freight charges as a freight forwarder. I'm going to handle the cargo claims. This has been a much easier sell to shippers than to try to set up a broker affiliate and explain to him that you're no longer responsible for the cargo claims. The above language is MAP 21 compliant. As I mentioned, has been used by several larger clients to establish partnerships with small carriers to get the dependable backhaul freight from credible logistics partners. So that very quickly, in about 25 minutes, is the presentation. I think I've probably given you a good bit to absorb here. I'd be happy to entertain any questions that anyone has about this alternative model or the winds of change that I see affecting the viability and necessity of its use. John?
Well, thank you very much for sharing all that important information. That was an excellent presentation and very interesting. And many questions have come in, so we'll jump right into them. The first one that we receive is, can you please elaborate on the issues and challenges with contingent cargo liability?
Sure. I'll give you a perfect example. I have a client who has brokered a good amount of freight to small carriers. They just got a claim in for $250,000. He turned to his contingent cover and filed a claim with them. The subcontracted carrier had $100,000 only. The subcontracted insurer said, we're not providing coverage under our policy for that kind of loss. So when he asked his contingent carrier to pick up the loss, the contingent carrier said, you didn't read your policy. Your policy followed form. All your policy was good for is for paying the loss to the extent the underlying carrier had coverage. So you ask yourself, well, what good was the contingent cover? It didn't cover the excess over $100,000. It didn't even cover the $100,000 because of one of these loopholes in the policy. And unfortunately, it's very difficult to find a contingent cover that will cover the excess over $100,000, which is the typical amount a small carrier has, but more importantly, which will come in and fill in the gaps in the coverage of the subcontracted carrier. Most frequently, all we can get in terms of evidence of some subcontracted carrier is what's called an accord certificate that says there's a policy. It doesn't tell you what the loopholes are. And what I'm suggesting is there is freight forwarder authority available. You're going to pay some cargo insurance for it, not an exorbitant amount, but you're going to know that you have coverage in the amount specified in your own policy, and your primary cargo carrier is going to have the right of subrogation over and against the subcontracted carrier and its insurer for recompense. One thing I would suggest in that scenario is that in your shipper contract and in your carrier contract, when acting as a freight forwarder, you provide that upon your request, any unresolved cargo claim can be submitted to binding arbitration. At that point, you get the subcontracted carrier to either put up and shut up, and at one time you can resolve not only the issue of the liability for the cargo claim to the shipper, but also have a judgment that then is good for pursuing the subcontracted carrier.
Thank you. And the next question we have is, how would this arrangement, and this question came in while you were talking about the freight forwarder scenario, so I presume it relates to that, work for an intermodal company when a bill of lading is not issued?
There is, and I do a fair amount of work in the intermodal space, and the absence of a bill of lading in the intermodal industry is a bit of a problem. In fact, we have for intermodal clients designed and put on their website a standard term of a bill of lading or a pickup receipt, which we provide applies by operation of law. Now, I know you're going to be a little silly if you show up at the port and try to find somebody to take that bill of lading, but the incorporation of that bill of lading and its terms and conditions into your website, I think, is important. And I think that, and if the caller wants to contact me, I'll be happy to provide them with what looks like a short form bill of lading that serves as a receipt and shipping document. It's a shame that we have so much freight moving in the intermodal space, and lots of times all we have is a UI interchange agreement to evidence the condition of the cargo. So that is indeed an issue, but I still believe it's very important that we have a document. In fact, the statute or the regulations provide, it doesn't say it has to be a bill of lading, but provide that the carrier must issue a receipt for the goods, and that receipt must show the origin, the destination, and the commodity of the traffic. So there needs to be some documentation, albeit intermodal, that the shipment was picked up in good condition and was delivered in good condition, and that receipt can serve as a bill of lading without it being a long two-page form. So if the questioner would like to contact me, I'd be happy to give them some information on that.
Well, we appreciate that, and we appreciate all the great and important information you've shared with us today. We also appreciate everyone attending today's web seminar. We're running short on time, so I'll handle one last question personally. Several people asked about the slides and presentation. They will be posted to Clinewood's website, and you can also contact Clinewood at university@clinewood.com for more information. With that, today's web seminar is now ending. We hope you all have a great day.